The amendment, by its terms, bars both heterosexual and homosexual domestic partnerships. It bars, by its terms, both heterosexual and homosexual civil unions. This is not the codification of existing law, but a vast expansion creating one of the most extreme and intrusive laws in the nation. Passage setting the state on a bitter and divisive 14-month campaign that will truly pit North Carolinian against North Carolinian, family members against each other, and serve only to create an atmosphere of tension and instability and the potential for acts of violence and prejudice on all fronts at a time when we ought to be focusing on exactly a different course. And we seek here to allow the public to vote on an amendment to the Constitution after less than 1 hour of debate in the Rules Committee and in a bill that was presented just shortly before that time now to the floor of the House of Representatives. And I ask you what the exigency is. Is it an exigency because there is a federal lawsuit pending or a state lawsuit? There's none. Is it an exigency because there's been a bill proposed to change the law on marriage? There's none, and there hasn't been. And so you fear, and the reason that this bill exists is a fear of an activist judge. Why? It won't take an activist judge to declare what I just said is the law, the law. In fact, it will simply take a judge doing their basic job in interpreting the Constitution. And so it has come to this on the floor of the North Carolina House of Representatives. We seek to amend the Constitution not on the merits, but because of our fear. So what's the effect of this ballot initiative? Well, at a minimum, it's going to affect the legal recognition of joint parenting rights, legal recognition of a child's relationship to his parents, eligibility for public housing and housing subsidies, access to spousal benefits under Medicare and Medicaid, the ability to enroll non-biologically and adopted children in public and medical assistance programs, the ability of parents to consent to the medical care or emergency care for their children, the ability to make Medicaid decisions, medical decisions for incapacitated partners, access to spousal benefits of workers' compensation, even the ability to travel with the child if that travel will require proof of parentage, and protections and compensation for families of crime victims and domestic violence. This amendment, in every way, and I speak as a law professor now as well as in my other capacity, threatens to alter the family law landscape in ways I don't think even the sponsors understand. You know, legal recognized relationships are supposed to be there as a coming together for better or for worse, hopefully enduring and intimate to the degree of being sacred. Marriage and those domestic partnerships that last a lifetime are associations that promote a way of life. And we protect family because it contributes so powerfully to the happiness of individuals, not because of a preference for stereotypical households. What's a domestic partnership? It is an agreement between parties that ascertain that their relationship exhibits the core characteristics like marriage. Domestic partnerships recognize families may include a third category of not married, not single people, and define that category using already existing legal principles so that it can be acknowledged by judges and legislators and employers and the public. And it has major responsibilities, one partner to another. Domestic partnerships are used in a variety of contexts, only some of which have been touched on by the second sentence of this amendment. And yet, we are about to allow an amendment to the Constitution to outlaw all of it. And I say again, not just with respect to homosexual partners, but heterosexual partners. You are passing an amendment, or asking the public to, that will literally affect the lives of hundreds of thousands of North Carolinians, and yet we stand here to debate it all in one day. Civil rights are not defined as a reward given by society for good behavior. The right that every person has, that Representative Keever talked about, to intimate association under the Constitution of the United States becomes meaningless if we say it only applies to heterosexual people. To be permitted to have a lifetime relationship with someone that has virtually no legal effect, including the privacy protections that are afforded by otherwise the state constitution, is a gross example of unequal treatment. Some have said, don't ever compare this to the civil rights movement. Don't talk about Plessy versus Ferguson, and don't talk about the Loving versus Virginia case. Those were issues better understood, they say, in separate but equal. Well, what this doctrine is creating in this amendment is tolerance but not acceptance, and it is no better than separate but equal. Marriage and family serve a number of functions, and the government confers benefits and protections on a vast array of people because of it. And family units allow the well-being of our society, regardless of how they are formed, to interface their energy and resources to accomplish for each other, to protect each other, to care for each other, to comfort each other, and we take it all away in this constitutional amendment. Family associations, in whatever their form, meet the human need for closeness and trust and love. And you know, for many people, it is family functioning that nurtures family values and the interests served by families that affect the quality of family life. It doesn't matter the form of the family. A limited view of marriage, a limited view of domestic partnerships, a limited view of civil unions directly contradicts the importance of family to the individuals and to our society. And the costs of us doing so will be extraordinary. If the tradition of our state is to deny important ties based on love, it is a tradition which relies in part on intolerance and fear. I would suggest to you today that a more powerful tradition exists in our country and in our state, and that is the tradition of pluralism, of making room in the law for all who wish to participate and meaningfully contribute to this state. The challenge, of course, is not to find the fundamental differences between us. It is to create law based on our shared values. And the test of freedom's substance is the right to differ as to things that touch the heart of who we are as human beings. And it was worth noting that what we seek to do today is not amend a statute. We seek to amend the Constitution, and it is a Constitution that we are expanding. In that regard, I want to read you an opinion from Justice Kennedy of the United States Supreme Court when he said, "The very purpose of a Bill of Rights is to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and establish them as legal principles to be applied by the court to life, liberty, and property, and those principles should never be submitted to a vote. They depend on the outcome of no election. Nothing good, in my opinion, has ever been done. The right thing has never been done from fear. And so many of the wrong things are done in its shadow. And we stand in that shadow again today. All of the phobias that we have are bricks in a wall that divides us. Bricks that cast us in a clay of fear. Fear of that which is unknown to us. In the end, these matters involve, that we talk about today, the most intimate decisions any of us will ever make. And at the heart of the liberty has to be the right to define our own existence, our own meaning, our own relationships. If that isn't part of our freedom of the North Carolina Constitution and of the tradition of being a North Carolinian, I do not know what is. The heterosexual majority in our country, in our state, not only deny love and commitment as values held by homosexual citizens under this amendment, but they prevent homosexual and, as I suggested, heterosexual couples from claiming them as values even when that is empirically not the case. The Constitution was not designed as a tool to divide the citizens of this state, one from another, nor as a device to maintain the majority's fiction about a minority. Its use to those ends, as has been stated by Representative Ross, has been a wrong that we have seen in this state and country over time. There are enemies enough, as 9/11 suggests, to the values we all share in this state. We threaten our own good when we create enemies of our friends. The Constitution holds equality up as an ideal, and it cannot be used to enforce inequality where inequality does not exist. The divisiveness and irrationality and fear that are really at the heart of this bill should not be tolerated. The law of North Carolina and the people of North Carolina beat with a better blood.